don't see you, JT, so you got to give me some. Okay, I see now that it's been switched on. So I'll wait a few seconds.
Yes, and I'm trying to share my screen to put up the board meeting.
Okay.
And here we go.
Everything.
All right. Okay, this meeting will be called to order. And before I ask the secretary to call the roll, I just want to remind everyone that under our emergency rule, allowing us to conduct our Board of Trustees meeting via video conference, we need to indicate the location of where we're calling in from. And so will the secretary please call the roll?
Chief Justice F. Philip Carbolito.
I am present, and I'm calling from my chamber at the Guam Judicial Center in Hagåtña.
Presiding Judge Alberto C. Lamarena III.
PJ, you are muted, PJ, if you can unmute yourself.
I always forget. Yeah, I'm present. I'm at the Guam Judicial Center.
Trustee, thank you. Trustee Cynthia V. Ikubi.
Good afternoon, Kathy and board members. Present here in my law office in Hagåtña.
Trustee Donna Muña Canata.
I'm present. I'm at my place of employment in Hagåtña, Guam, East Hagåtña, Guam.
And Your Honor, I mentioned earlier the Guam Bar President Jackie Titorlahi said she'd be in a little late.
All right, so Secretary has certified that we do have a quorum. We have 4 members present, and we can duly conduct our business. And so the first item on the agenda has to do with the approval of minutes of the regular scheduled meeting of December 17th, the reconvened meeting of January 14th. Let's start with that. Is there a motion to adopt the minutes as indicated, subject to corrections?
Move to adopt.
And is there a second to the presiding judge's motion to adopt? Attorney Ekubi, or you can unmute yourself, and for now, let's unmute ourselves.
Okay. Thank you, Your Honor. This is for January 14th, Your Honor. I'm not comfortable with the January 14th meeting because I was not a board member at that time, so I don't have, I wasn't present at that meeting, so that's why I was a little reluctant to, with regards to the January 14th meeting, Your Honor. I came in after.
Yeah, same with the way we all did. Same with the December 17th, the January 14th, and the only one that were present during those meetings were the presiding judge and Jackie Terlahi. So subject to the caveat that you are not present, and it's based on the tape that these meetings were properly transcribed, I would entertain a motion to second the motion, recognizing that you are not present at the meeting. That's okay.
Okay. So that would be 2 motions then, correct, Your Honor?
Yes, that's correct. So on the
Okay, Ms. CJ, I'll amend my motion to include that those who were not present can rely on the copies of the transcripts that were submitted, that were given, done by the Public Defender's Office.
Then I'll go ahead and, in light of the PJ withdrawing his initial motion, amending it with that caveat, then I'll second the amended motion.
All right. So on the amended motion, all those in favor say aye.
Aye.
Aye. Those opposed, it's been unanimously adopted. So the next minutes of meeting for approval is the regularly scheduled meeting of May 26, 2020, in which we were all present, and I will entertain a motion to adopt.
Motion to adopt the meeting, minutes of the meeting on May 26, 2020.
Okay, by trustee member Donna Muña Canata, It's been moved.
I'll
Is there a
second that motion.
All right, been seconded. All those in favor say aye.
Aye.
Those opposed, the
Aye.
minutes of meeting has been unanimously adopted. If there is no objection, the speaker has asked to make some comments in reference to item E of our under old business. I'd just like to go down to public discussion for this purpose, and then we can go back and start with our regular business, starting with item A under old business. So is there any objection so that the speaker can make her public hearing, and after making her comment, for her just to make the comments under public discussion?
No objections.
None, Your Honor. No objections.
There being no objection, and I assume the twin also has no objection, so we'll go down to the public discussion. And Madam Speaker, you are recognized.
Undunklin Asidros Masi, Chief Justice, to the members of the Public Defender Service Corporation Board of Directors, Undunklin Asidros Masi, for giving me the opportunity to present some kind words of support for a program that I truly believe in my heart. And I want to take the time to thank you for letting me speak soon, as I have the Mayor's Council's budget hearing that I need to go to. So if I may, Sidros Masi, Hafide,
Please.
and can I proceed, Chief Justice?
Yes, Madam Speaker, please proceed.
Hafide, thank you again for allowing me to reiterate my testimony in support of the Public Health Legal Assistance Services for Seniors program. As you know, the Public Defender Service Corporation is very near and dear to my heart. Working as a file clerk all the way up to investigator in the years that I was at the PDSC family, I still remember many of our elderly clients coming in, bringing in homemade bananas and fruits from their yards just to express appreciation for the invaluable help the Public Defender Service Corporation family had provided to them. The PDSC team has always fought hard for their clients, dedicating their time and effort to providing our clients with the best service possible. It was 100% a team effort. So it was with a heavy heart that many years ago, we, and I know Chief Justice is aware of this, signed a moratorium in the early 2000s that limited services to our indigent population. Bringing back this senior program to the Public Defender Service Corporation family truly right-sizes the public defenders and is in line with the public defenders enabling legislation to render legal aid and assistance, especially in civil matters. As you know, our SINAs, our men uncles, will only ask for something when they truly need it. It takes a lot for them to come down to ask for any kind of help. Usually, they just need assistance with simple matters that are not fee generating, like deeds, doing things for helping family members or appointing agents to act on their behalf, especially as they reach their end stage. They come to the public defender family with the foresight to settle their matters while they are still alive so that their families aren't torn apart or stuck in probate. Something that happens far too often in our community than we would like to admit here on our island. Approximately 20% of Guam's population are 55 years and older or and above. While many of them are still well and able and working in their retirement age, a lot of them are ready to make their end of life planning, but don't know where to turn to with their limited pension. This program would be a one-stop center for senior citizens seeking help for many legal challenges that they may have. Lastly, I want to note that the Public Defender Service Corporation was established to help any vulnerable indigent who needed legal representation, especially in civil matters, according to our Guam Code annotated 12 GCA section 11105. This program is in line with our enabling legislation. And I want to say that if it is the will of the Public Defender Services Corporation to not support or not to provide services in civil matters to our seniors, then what they could do is share a resolution so that we can work on the legislation that we still have pending here at the Guam legislature. When this bill was introduced back in May of last year, it was the intent to work closely because I was so passionate about bringing services back. I had asked legislative secretary and others to help me in this effort. And it would include to work, have the public defender's family work on cases that will help our manamco, but more importantly, to do and give them assistance to simple items that our manamco really needed. But this would also allow the corporation, our public defender family, to apply, receive, to administer grants, sub-grants, or enter into intergovernmental or intragovernmental agreements to provide legal services to individuals from vulnerable, underserved, and underrepresented groups, including but not limited to our elderly and victims of violence, individuals with disabilities, individuals and families of low income, and members of ethnic or sexual or gender minorities, as defined pursuant to the local or federal laws, regulations, or guidelines. The corporation would be authorized to comply with the requirements of the federal grant, sub-grant, or any of the intergovernment or intragovernmental agreements to include representation to individuals who may qualify for services pursuant to the terms of the federal grant, sub-grant, and of course, intra or intergovernmental agreements. I say that with a lot of heart and a lot of passion to the members of this public defender family, because I truly believe that if we can bring back a little of what we used to do many, many years ago, it would bring back the support to helping those that are vulnerable as it relates to our SINA. I know that in the past, we've also created what we call the alternative public defender. I know that when the enabling legislation was done as far back as when public defenders was at the Public Health and Social Services Division, that we knew that we wouldn't be competing with private attorneys as it relates to fee generating cases and other cases that would compete with the private sector. And it continues to be that same thought that I share with. But a lot of times our manamco just need a sense and a place to go where they trust and know that they have. And it's not like we haven't had it in the past for many, many years. I want to literally correct or at least right size something that this can do. In the same effort, I am committed as a public servant and as a policy writer. I know that the oversight chair on law, the good senator from Jonia is also on board at this meeting, and I know for many years on being an attorney, the efforts of helping our signers is very keen and very important. And for many years, the public defenders, in the 15 years that I was an employee with the public defender's office, it was those kind of cases that we helped supported, and even a lot of other civil cases that were not fee generating that we were able to support. I'm not asking for all of it right now. I'm asking it for our most vulnerable. A lot of our seniors that are literally at their end stage of their journey on life here on earth need just a little, whether it be a power of an attorney, whether it be an affidavit, whether it be a deed, whether it be that last will. I know that a lot of them live on a pension that cannot afford them anything else. And I'm just hoping that if you can consider this and give it its blessing, that we can go a long way. public defenders has always been there. And for the years that it had to put this moratorium in place, it literally broke my heart. And as passionate and as sincere that I'm getting about this, a lot of times when they come to my office, just trying to give them the services and help them through the other federal grants that are out there, the difficulty is so hard because the waiting list is so long. And we also have former employees that work in those different areas that are trying to help. But I know that if this comes back to the public defender's family, that we will be doing good for our sinus. And I cannot but implore and continue to say that. And I know that I'm usually open to a lot of questions that you may have, but I want to apologize again because I have to go to the budget hearing for the mayors. But I'm hoping, and I want to thank you, Chief Justice, because in your efforts and commitment to at least hearing this again, you held true to your commitment, and you are affording me the opportunity to speak to your board of directors to share my sincerity of how I want to see this program work for our sinus. And it's just from the heart. Thank you.
Thank you, Madam Speaker. And your support and passion for the issue comes loud and clear. And your comments, it's all part of the record and will be taken into consideration when we further discuss this item on the agenda. But thank you for your presence, and we very much appreciate all your comments. And we will continue to deliberate on this, and the board will make a decision on it, one way or the other.
I want to thank Bruce Mossy and Sina Mossy for giving me this opportunity again. And thank you. I must depart now. God bless you.
All right.
And
All right. Thank you, Madam Speaker.
Sina Mossy.
Goodbye. So now we will go back to old business, and the first item in the agenda is the financial status update from the PD and the financial status update on the allotment releases. And I will recognize our controller. Who is going to report on this, Kathy?
I will be reporting, sir.
Mike Moreno.
Okay. Yes, Mike. Go ahead, Mike.
Yes, thank you, Your Honor. And good afternoon, everybody. For Public Defender Service Corporation, we are at 97.5% of allotment releases that we have received already. And yeah, 97.5%. And for the DVP, for the Domestic Violence Program, we just have received the Amendment 3, which which added on funding for the Stop 2017, which will last until August 31st. Reimbursement requests have been submitted from January to May, and we should be up to date pretty soon. We are working on Stop 2018 for funding up to December 31st. That has not been finalized yet, but it's a work in progress. For the alternate public defender, we have just received our third quarter allotment on June 12th. And this quarter, we are at 100%. And we will be issuing another invoice for the last quarter of this fiscal year next month. And that'll be all. If anybody else, anyone has any questions, I'll be available.
Does anyone have any questions for Mr. Moreno? So the bottom line, Mike, is that the administration continues to keep fairly current in the allotment releases. Is that correct?
Yes, Your Honor. Just a point of note, in the beginning of the pandemic, the governor's office took out $179,000 from our approved appropriations, and we still need to get a confirmation from Department of Administration whether that money will be coming back through the CARES Act. We have not received the confirmation yet.
Oh, okay. I see now. Yeah, you need to follow it up, and if I can suggest, Steve and Kathy, that you put in writing the follow-up request. We did everything in reference to our follow-up. We put everything in writing, and we have been reimbursed in reference to the amount that was originally withheld when they tried to come up with the $4 million, when they came up with the $4 million funding at the outset for the quarantine sites. And I suggest that any letter communicating and requesting that be reimbursed back to the Public Defender Service Corporation, that you do that in writing.
And Your Honor, we did communicate with BBMR. They sent us an email saying that they actually never withheld any allotments to pay for the quarantine. So, but we'll get something more formal. But it's kind of ironic because John and I had to help these quarantined residents get released from the hotel. So we're like, part of our budget was being used to pay for it, and we were going in there fighting it. But anyways, we've gotten assurances that they're not going to take it, but we'll get something more formal by the next board meeting.
All right, thank you. So the next item on the agenda, if there's no question in relating to Mr. Moreno's report, is the report from the Executive Director, our Public Defender Service Corporation, on the update on remote hearings. Mr. Hattori.
Okay, thank you, Chief Justice. So we recently obtained 15, I guess, webcams. So our capacity is growing, and so we are Zoom capable right now. We've been doing hearings pretty much, maybe 3 or 4 courtrooms have been using Zoom. The rest we've been doing it by teleconference. And so it seems to be working out really well. We're also e-filing all our documents, and that's actually works out really well. I think it's going to make both the courts and our office more efficient. And so the issue we haven't been able to resolve is how are we going to get our clients to participate in these hearings? And so for the most part, some change of pleas have been happening through Zoom or through, I think someone did it through Zoom, but Judge Socola, she's wavering between doing it in person and setting something up at the Judicial Education Center. But we are working with the trial courts on figuring out how we can have hearings while maintaining social distancing.
You know,
So
Steve,
go ahead, PJ. I'm sorry.
Steve, you know, I just to expedite matters and to reduce the exposure of people from COVID-19. You know, I talked with some of the judges, and they're amenable now to, in misdemeanor cases, where the defendant can waive his presence, okay? And the attorney of record can have the defendant sign a written consent and submit it to the judge, and the court will accept the plea agreement. I think one time you and Annie offered to submit a waiver form.
So yes, Your Honor. So we're working on that. I know that especially in your courtroom, the attorneys are aware of that procedure. So, I mean, we could roll out the form and send it to the court if they want to see a draft before we start using them.
Yeah, I appreciate it if you could send one like by the end of the week. Basically, you just follow the 1.13 and the 1. I think one where the defendant is you have to enumerate the rights of the defendant, and then the next chapter, the next section that he can waive his presence for change of pleas and sentencing for misdemeanor cases, of course. This will only apply to misdemeanor cases only, not from felony to misdemeanor. Okay, so it must be so if he's charged with DWI misdemeanor, he pleads to a DWI misdemeanor or a lesser misdemeanor like reckless driving. But if he's charged with DWI third-degree felony and he pleads guilty to DWI misdemeanor, then that still has to go to the normal process. Okay, you understand what I'm saying?
Yes, Your Honor. We'll have that sent to you.
So that would eliminate a lot of people coming into the courthouse, and we'll work with probation to make sure that these people will walk into probation, be processed accordingly.
Okay, yes, Your Honor. We'll work on that and we'll have something in the next day or two.
Okay, great. And then can you email it to me so I can show it to the judges?
Oh, yes, Your Honor. We'll have it by tomorrow.
Okay, thank you, CJ.
All right, thank you, PJ. So Steve, the PD has purchased 15 webcams, and I assume you will be assigning those to the lawyers. And so can I represent at our Robes meeting that the PD is fully capable of increasing their usage of the Zoom platform for remote hearings? And what fiscal location are you going to be utilizing in the event that you need to bring in your client or the respective clients of the PD to participate via Zoom?
Yes, sure. And that's the problem. We haven't really resolved that yet. So we have 3 video terminals set up for the public to access, but those will probably be used for appointments. And since we only have 3, it'll be difficult to accommodate court hearings and have our clients present there. But we are working on getting like a wireless router that would enable clients to participate from like the comfort of their car in our parking lot. But we're not sure how soon we're going to be able to get that. Apparently there's some broadband wireless network that we're going to be able to procure that will expand our Wi-Fi network to about 10,000 feet or meters. I'm not sure. JT would know the answer to that. But so the thought is that, even clients that we need to meet, they could come access our Wi-Fi network and we could Zoom and have Skype meetings with them that way.
So, but in terms of participating with a judicial officer, a trial court judge for a public defender hearing where a public defender is appearing, and we don't, we're trying, of course, as much as possible, minimize in-person hearings, and that although that discretion is ultimately with the trial judge, the first preference is to have it either teleconference or virtually for hearings that can be accommodated that way. And so if the PD client has to be appearing via Zoom, is there a conference room? Are there conference rooms or located at the public defender, or some plan to set where this participation via Zoom can be carried out?
Well, I mean, right now we only have three areas that we could allow them to Zoom from, but those are going to be used for appointments. And
Right, but I mean, isn't there a scheduling that you can do? I mean that's the feedback I'm hearing is that PD is not they're resisting in reference to appearing via Zoom, and the implication is that the only thing that is of interest is to have an in-person hearing, and right now that's not the first order of choice in reference to the Supreme Court's administrative order and how we're conducting our business.
yeah, that's correct. I think the problem is that since we only have 3 computers available to the public, it would be hard, I think, to really schedule that along with all the appointments that we're using them for. So, I mean, when we do get our Wi-Fi network, then I mean, we can let clients, Zoom in from their phones in our parking lot. But we've been successfully meeting clients using Skype, Facebook Messenger, and other video conferencing apps. So some of our clients are able to get into Wi-Fi zones and are able to, they would be able to Zoom in from their location. But the difficulty we would have is like if we if we're expected to have like say 5 courtrooms having hearings at one time, we would run into conflict of time problems, and then, managing that many clients coming in could eventually prove difficult. I know APD might only have the capability for one, one client contact at a pretty much per hour. But yesterday, like Judge Sokola had about 15 hearings in the morning, and it would just be hard to manage all 15 of those clients if they showed up at our front door, waiting for court hearings.
You have any suggestions on that, PJ, in reference to how? Well, let me just say that we are continuing to build out our resources to be virtual capable, and I'm wanting the public defender also to try and extend its capability. You've started the process by purchasing these webcams, but now you need to use them. And in terms of facilities, if there is a temporary facility where they can be accommodated with proper social distancing within the webcam's scope, then I think I'd like for the public defender to research that and see what type of cost that's going to that will incur, and that we can look in reference to if that's something that is that can be afforded. But this is the direction we're going for this period of time, and so I'd like to see that the public defender and APD try and do as much as possible to be able to participate in the hearings via the virtual platform or teleconference. Anything else for Mr.
We'll work on
Hattori?
that.
What about you, Annie?
Good afternoon, Your Honor. Thank you. As far as APD is concerned, we do have, we are able to accommodate only so far, mostly telephonic conferencing. We're able to have our clients call in to the hearings. We get the notices from the court and we get the number, and we're able to share the telephonic number. We are also able to, on a very limited basis, allowing, like I have a sentencing hearing tomorrow in front of Judge Senzon, and I have been allowed, my clients in DOC, I have been allowed to share the Zoom with one of the witnesses I'm going to have to testify. So on a very limited capability, we are able to accommodate the Zoom platform that the court has directed us to use. What we're running into difficulties, at least we're trying to work out how we will have court interpreters getting involved in, perhaps if they're at the court, we can have them Zoom in for change of pleas or things like that. But we have the one room for the clients to come in for appointments, and we're able to conduct our attorney-client meetings in that, using this Skype for that. As far as bringing in clients for Zoom hearings, we aren't ready for that. We're getting there, but it's more having them use the Zoom on a call basis. And so far it's been okay. But I am working out with whenever it's a different judge, whatever they're using. Judge Sokola prefers the telephonic calling in situation. So does Judge Kwan, Magistrate Judge Kwan. So we're trying to just figure out with the different judges until we get more direction from the Superior Court. Judge Barcinas said that there's going to be some rules and regulations for that. And so that's what we're waiting for. And we were trying to figure out with Judge Barcinas, working with the mayor's offices to get our clients able to go to the mayor's offices for some of the Zoom hearings. And so I was talking with the Lieutenant Governor as well as the legal counsel for the Governor High Twin. And so we're looking at perhaps asking the Mayor's Council, and Miss Kathy Angogri was helping us contact and reach out to the Mayor's Council to see how we can accommodate our clients, perhaps having 4 different satellites at different mayor's offices to see if we can accommodate our clients that way.
All right.
So it's a work in progress.
Okay, and I'm asking that you continue to work on this so we can try and be all on the same page to work more efficiently.
Thank you, Your Honor.
Thank you. Any questions for Mr. Hattori or Ms. Annie Yale? All right, let's go ahead and move into item D under old business. And this is the performance evaluations for both the executive director and managing director, managing attorney. Let me just say that where we're at on this item is that there was a meeting on January 14th that made certain decisions regarding the performance evaluations. That was done in executive session. There's been a legal opinion that was not in conformance with the open government law, and that the decision that was voted upon was null and void. And so unless someone objects to that legal conclusion, where we're at is that we have a performance evaluation that was completed, and there is a decision that has been set aside in reference to the conclusion of that performance evaluation. And as I see it, that's where we're at right now to decide whether or not we want to revote on the performance evaluation if in fact the members who were not present can and are willing to participate in that vote, or do we consider other options in reference to continuing the review of this performance evaluation. Presiding Judge, do you have any sense in how you'd like to handle this?
Well, you know, since 3 of the 5 members are new, I don't object to give the opportunity for the 3 new members to review the performance evaluation so we can discuss it privately. And then, because, you know, I just want to make sure that the 3 new members are comfortable with the decision, and I just don't want the 3 members to feel that they have to adopt the decision made by the prior board. In fact, I was going to make that that recommendation anyway, to give the opportunity for the 3 new members to look at the performance evaluations. And if they want to affirm the decision made by the previous board, they could do so. If they want to make amendments, they could do so. Or if they want to come up with their own conclusions, they could do so. But I'm open to let every member the opportunity to evaluate the and analyze the performance evaluations made by the board earlier.
I think that's a good recommendation, and speaking for myself personally, I think that is a fair way to proceed. And the only caveat is I want to put a time limitation, and that we, if in fact this is the direction we go, considering the input of the other trustee members, is that we undertake that review prior to the next board meeting, so we can make a decision one way or the other in reference to the performance evaluation. So the effect that members, the affected parties do not, this is not further delayed. So Donna and Cynthia, do you have any, QB, do you have any thinking in reference to how you want to proceed?
Your Honors, I would join in with PJ's comments. Again, I would just reiterate, I was not a party or a trustee at the time, and I myself haven't had the opportunity to avail to be really part of the process to know from, in order to make the, recommendations leading to the evaluation. So I think additional time now with the new membership and new members would be a good opportunity to really discuss this and determine whether or not we either accept it, we reject it, or there's some other modification and or options. So I would tend to, I would join in that with the PJ that, I think till, and as well with you, CJ, that there be a timeline. But I think, for myself, I just didn't, I have not had any time, and it's not fair to the parties, to just go ahead and make a final decision today. So I think just some additional time with the note that we put a timeline on this. So I would agree that maybe just additional time till the next board meeting, and then we could discuss this in detail.
All right. Donna, do you have any comments in relation to this issue?
Sir, yes, I do. I do believe that I do need some time because there are a lot of questions that I have after listening to that like, how long was the executive meeting? Was it only like 24, 34 minutes? Because I could only hear 24 minutes of it. So was that meeting only 24 minutes or was it longer? And there was some comments I wanted to ask, and there was nothing in front of me for me to look at. So I'm hoping that, I guess I'm with you, Your Honor, as well, that I want time. So along with you, not to extend longer than the next 30 days, if that's okay with the rest of the board.
Yes, I think that's the consensus of the board members present. So what we're going to need, Kathy, is whatever written performance evaluation was completed, that be provided to the board members if there was any type of written evaluation that was filled out. And then from there, we can have our own discussion. And of course, we would very much consider the input of the presiding judge and Jackie Terlahi, who's the president of Guam Bar, who were present during this period of time. But the options, as the presiding judge has briefly outlined, I think is a good starting point for us to pick it up. And we need to bring this to closure. The performances of our executive director and our managing attorney, we need to bring that to an end one way or the other. And I'm hoping that we can dispose of this at the next board meeting, one way or the other. So with that, I will, maybe PJ, you can just make a motion that we table this to the next board meeting with the conditions that we receive any and all performance evaluation materials relating to the review of our executive director and our managing attorney.
Okay, I move that the final evaluation be postponed to the next meeting, and the administration, Kathy, will provide all the necessary documents to all the board members necessary to make a decision.
And is there a second to that motion?
I'll second that, Your Honors and trustees.
All right, it's been moved and seconded. Any further discussion? There being none, all those in favor say aye.
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 Those opposed? So it's the ayes have it, and it's been unanimously adopted. And Kathy, this will be, since it's a personnel matter, this matter will be discussed in the executive session, so you can have it included in the executive session part of our meeting. And then pursuant to Mr. Morrison's legal memo, any decision in relating to the discussion will be conducted in the regular open discussion part of the meeting. All right, so the next item on the agenda has to do with the Legal Assistance Services for the Seniors Program. And this is what the speaker had addressed. And this is again back on the agenda for further review. And we have a PowerPoint that seeks to address some of the concerns of the board members at the last meeting. I'd like to just start, if there's no objection, just outlining my position on the matter. Number one, I think it's been made very clear by all board members that we are all very concerned with elder legal representation. Nobody disputes that there is a need and that it is a segment of our community that we would all like to help. I think everyone has a very sincere, legitimate interest and concern that the Public Defender Service Corporation, first and foremost, is set up for indigent criminal defense, and that should not be compromised or take a second position. And I share those concerns. And however, I feel that the circumstances are such that we can address the obstacles and test whether or not the concerns cannot be overcome. Number one, this is a pilot program that we are going to see if the Public Defender Service Corporation can continue to service the indigent segment of our community in terms of criminal defense, which is first and foremost the priority of the corporation. And number two, that a conflicts wall be properly set up so that the lawyers in the Public Defender Service Corporation are not conflicted from any service that is being provided by the legal assistance program for our senior citizens. And number three is that the resources of the public defender are not tapped to support this part of the services corporation, because as we are all cognizant of, we're in for some very challenging times. And this affords the corporation for hopefully additional resources to be able to provide this assistance to the elderly part of our community. And so the pilot program gives us the opportunity to test whether or not we can undertake this responsibility and additional tasks without compromising the primary responsibility of the Public Defender Service Corporation. And it's with that understanding that I voice support for the limited trial of this program. So I will open it up to the floor for any comments. Does anyone like to say anything in reference to the topic before we decide the process of how we can proceed, how we should proceed?
Chief, this is Jacqueline Terlahi, the president of the Guam Bar and a member of the Board of Trustees. Can
Yes.
you hear me all right?
Yes, I can see your hand now.
Okay, yes, thank you. You know, I mean, first of all, Chief, you know, this is a project I know that has been kind of in the works for quite some time. My concern is during this process right now with COVID-19 and our PD's office unable to even set up our clients in order to address criminal proceedings, that right now may not be the best time to enter into this type of even pilot project, simply because if we can't do something as basic as getting our clients in the office or in a space to participate in virtual hearings, I'm concerned that we're going to tap and exhaust our resources in the criminal side, attempting to establish this particular program at this time. I agree with you 100%. There is an absolute need. This is something that we have been discussing for over a year in terms of the absolute need that is needed in our Manumco society for legal services. I don't oppose that kind of project. I just simply believe that with the strapped resources that we're facing, that implementing this kind of program, even on a startup basis, may result in reduced resources for our criminal obligations. That's all I wanted to offer at this time.
Thank you, Jackie. Those are very legitimate. That's a very legitimate concern. Mr. Atori, do you want to? I'm sorry, PJ. Go ahead, presiding.
I see that Art Augustine is present with us. I think,
Yes.
Mrs. Art, you're the administrator of this program, right?
I'm sorry, sir. I'm trying to unmute.
I'm sorry?
Yeah, yes, I am. Yes, I am, presiding judge.
Yeah, you know, can you address Mr. Lai's concerns about, you know, the logistics in making sure that the Manumco are safe?
Sure.
COVID
Thank you for that.
many of them are elderly.
Sure, absolutely, presiding judge. I just sent Steve a comment if I could, you know, asking if I could comment on the president of the board and your board member, Attorney Terlahi. So just to share with you, we have our office space available, and I have since had that place vacated in anticipation, in hopeful anticipation that we could start the pilot. In addition, we did receive funding, what's called the Aging Disability Resource Center, No Wrong Door grant. And one of the components of that is we are working with the University of Guam so that we can engage their services. And one of the areas we're looking at is the ability to build our capacity, like for Zoom calls, and to have technology become part of our service continuum, because the ADRC intent is really to look at what are the new types of employment and workforce coming up as a result and in response to COVID-19, and how are we going to do business today. And so in terms of accessing our seniors, we also do Medicare counseling, and we are now having our seniors come in to the office, you know, and so we do have some funding available that we can use under the CARES Act and under our ADRC NWD grant that could help with the technology aspect if we need to go into Zoom calls or cell phones or whatnot, so that we can do something like what we're doing right now with the attorney being here and reaching out to the client. And we already have existing systems like case management, where if seniors need legal services, they would be referred over here. We do, like I said, we do Medicare counseling because we have a information referral and assistance component here in the Division of Senior Citizens. And so we do have some resources. We also have some funding that we can make available. And this is not to pull from the legal assistance services funding that we have earmarked for the program, for the partnership. This is something that we're going to do just as an approach. Okay, that wasn't. So sorry, I thought that was, oh good, I gotta turn my phone off. So we have funding available, and that funding is really for us to basically prepare our office for the new way that we may be doing business, because we do Medicare counseling as well. So I hope that answers the concern or addresses the concern. I hope, and let me know if I need to elaborate a little more.
And I just want to say, Chief, we do have a presentation that will address Mr. Lahi's concerns. We are capable of Zoom. We're probably more capable than we're definitely more capable than the AGs. Our employees are at least showing up every day to work. And so, but I am just not comfortable exposing my employees to having all these clients come for a court hearing. And so, but if we're ordered to have our clients show up at our court hearings, and if the court's going to order the clients to show up at every private attorney's offices for court hearings, you know, if that's an order of the court, we'll follow it. And we have the capability to do it. But we, you know, part of it is, you know, we're protecting our employees by reducing social contact. And then we believe that the court, you know, should be hosting these court hearings, you know, on court grounds. You know, there's a certain solemnity that comes with having court hearings in a court setting. And so we believe that and we've suggested it, you know, that they hold it in those attorney council rooms. The Guam Bar could upgrade their internet to the highest speed possible. They could easily set up computers there with webcams, and they would have 6 mini video courtrooms available in the courthouse, and they could wait in the atrium 6 feet apart. But we don't have the personnel to support that here. But if we're ordered to, you know, we can.
Well, Steve, I think we all have respective concerns for the safety of our employees and the general public, and so that is mutual. And we are working in that direction to provide space where these hearings can be conducted in a virtual format without in-person requirements, with the proper social distancing, and exploring those other rooms as you've just raised. That is a work in progress. We're hoping to be more proactive and have results in the very near future. But that is, and we just want to make sure that everyone is making the additional effort and not just say, you know, we're not capable of doing it, and the effort stops there. That's not what I'd like to see. I'd like to see what the resources you have, taking into concern the CDC requirements and the safety of the Public Defender Service Corporation employees, and trying to balance all that. That's all that is being requested, at least on my part. And when we're doing our part to try and have our facilities Zoom capable with those safety precautions also taken into consideration.
And Your Honor, you know, we've also conducted Zoom training with all the attorneys. So we are totally geared up 100% to support the court in this venture.
All right. So we still have, like I said, we're going to go until 2 p.m. We still have approximately 30 minutes. And you said you have a PowerPoint that you wish to present. Does anyone have any objection to allow Mr. Hattori the time to present his PowerPoint in relation to this issue before we continue to deliberate on this? So,
May I ask?
No objection.
thank
But
you.
can we
No
ask questions?
objections.
Wait, all right.
May I ask
Go
how
ahead, Don.
long the presentation is?
How long's the PowerPoint?
Trustee Kanata, it shouldn't be more than 15, 20 minutes.
Because I like to make a comment after that presentation.
I'll allow you to do comments. I'll be short and sweet.
Okay,
All right.
thank you.
Go ahead.
Okay, I'm going to go ahead and begin with the PowerPoint presentation, but in your board packet, we had a complete write-up. And if you notice in the packet, on the bottom right corner of your board packet, there are numbers in green. We start with the seniors citizen legal assistance program on page 33 of 67 bottom, but the PowerPoint presentation I extracted information from the proposal we provided you folks. So if you just follow along with me, we'll go ahead and go through it right now, slide, please. So let me just recap. We went back to our board resolutions and identified when we had the moratorium, November 1999, June 2003, and August 2012. In 1999, we weren't able to get what our caseload was, so we used FY 2000. That was when we implemented our abacus law. So the caseload that we had, which is comparable to what we would have had in November 1999, our caseload for 9 attorneys was 1,911. In June 2003 was 1,991 with 9 attorneys. And in August 2012, the caseload was 2,091 with 15 attorneys. With that, next slide. So with, I'm sorry, JT, go back. With those caseloads, I'm sorry, I'm gonna go back.
The screen is not being shared right now. The screen is not being shared.
Oh, thank you.
Share. Are you guys able to see the screen?
No,
Mhm.
no.
Yes.
JT's trying to figure out how to share our
Oh,
screen.
yeah.
Oh,
Can
Yeah, I
you
can't
go-
see it on my screen.
Yeah.
oh,
There it is.
Thank you.
Go back to the cases. No, back. Previous. Okay, so with the moratorium, I'm sorry, we thought we were sharing because we see it on our screen. But with the caseload, I had mentioned in November 1999, we didn't have abacus law in place, but we had it for FY 2000, June to 2003, and August 2012. So you see the caseload, and in parentheses is the number of cases we had and the number of attorneys off to the right. So for 2000, our attorneys were running 212, on the average 212 cases per attorney in 2000, which we were using for 1999. In 2003, our attorneys were handling a caseload of 221. And in August of 2012, our attorneys were averaging about 139 cases for the 15 attorneys we had. Next slide. So in going back to the board documents and checking what were the primary reasons for the moratorium, as I showed in the previous slide, was the caseload. So that was the number 1 reason, heavy caseload. Number 2, ethical responsibility to provide competent services to our clients, budgetary constraints, malpractice, and conflicts. Next slide. So our heavy caseload today, with Executive Director Hattori, we've tried to right-size our attorney client ratio. So in 2016, we had 1,757 cases. So you can see off to the right how our caseload has declined as we proceeded through the fiscal years in 2019. And next slide. I also provided a chart, a pie chart that shows you how our caseload per attorney has decreased from 2016 to 2019. Next slide. So number two was ethical responsibility. And I believe that what is our responsibility, not just to our criminal cases, but if we were to take on civil matters. So we've reduced our attorney-client caseload. So today, bullet number 4, our average attorney has anywhere between 80 to 85 cases for fiscal year 2020. So we reduced it. I can't imagine any judicial officer saying that they have problems with our attorneys with the quality of work we are now providing today for our clients. And ethical responsibility for the legal assistance services that we want to provide with the Department of Public Health and Social Services. We have already identified 2 retired attorneys that we would like to bring on who have focused on civil matters and can handle powers of attorneys, deeds of gift, wills, and guardianship. So I think that we're living up to our ethical responsibility. Next. Budgetary constraints. So Trustee Guam Bar President Terlahi mentioned about a possibility of using our money, public defender money for this program. This money is coming from federal funding and the local match with public health. So we're looking at, for fiscal year 2020, 192,144 just for the 3 months, the next 3 months of the fiscal year that we would have reserved for this program. Whatever we don't use, public health already checked with their grantors, we can carry it forward to FY21. So we've got the 192 plus whatever is available from fiscal year 2020 that will be carried forward to 2021. And this is for this fiscal year plus 3 additional fiscal years. We're looking at 192,000 to support this program. Conflicts to whatever, this money that is also available, if there are any conflicts, we are going to use that money to send over to the Guam Legal Services. We've got a memorandum of we've got a commitment letter from Attorney Dan Summerfleck that was included in your packet that you folks received with your board packet. And we will also use that money to hire retired attorneys to handle the program. And it would also include associated office expenses. Next slide. Malpractice, I know that was a concern as well mentioned. With 2 seasoned attorneys, one with 40 years of experience in civil matters, and another attorney that we've talked to who would help us with the program, has 20 years. So we have a combined 60 years of experience for civil matters that we will have handling the program for public health and public defender. We will ensure that the attorneys, like we do here in our office, that we follow the rules of professional conduct and Guam laws that our attorneys need to adhere to. In your packet, we also provided the SOPs that we have in place that include the representation agreement that we will have with our seniors that we will assist through the program. Next slide. Conflict wall. As Mr. San Agustin mentioned from Public Health, we will have a dedicated office space free of charge to our office to use. So we will have individuals, the retired attorneys, physically up at Public Health. So it'll be the same arrangements that we have with APD. We'll have the case management system that Mr. San Agustin mentioned. We've also included in the budget, which is a part of your packet, the procurement of abacus law that will come from public health. We believe that conflict wall will reduce not just conflict with the civil matters, but also criminal matters, so that it is physically out of our location here in Sinohanya. Next slide.
And that's the beauty of the program, is not only does it prevent conflicts, but it reduces conflicts. We will be able to handle more protective orders in a civil division because we won't have to withdraw because our criminal side represents them. Likewise, we will not have to get rid of out of criminal cases because our civil side has sought a protective order against them. So this thing doesn't just eliminate conflicts, it reduces future conflicts. Not only that, we'll shift the civil work that our criminal lawyers are doing now over to the civil division. And so the average caseload will go down if we move the civil work to a civil division. We ran stats in February in 2019. The average caseload per attorney, if we had 16 attorneys handling all the cases, criminal and civil, was 92 cases per attorney. If we had 15 attorneys handling it and 1 attorney dedicated to handle the civil, the actual caseload would go down to 85 cases per attorney. So we're looking at actually reducing caseloads because of the amount of civil work we do. The civil division will take that work. And so the Gov Guam's already paying for that civil work. We'll just shift it over to the Outer Justice Center, the civil division. And so they're going to actually reduce the overall caseload for the criminal lawyers, and they won't have to cover things like guardianships, contested protective orders, and contested guardianships. Ask Ms. Sakubi about a contested guardianship we had that took 2 weeks. And so the civil division would be able to handle that, and it'll eliminate and reduce conflicts. Okay, thank you, Kathy.
Thank you. here we have our conflict wall. I know that when Edie Tori started with our office, we started about the same time. We reduced our conflict, and these are our numbers from Abacus Law, our case management system, our CMS. And you could see that we have lowered our conflict, and I would believe that APD will also share with you folks that they see less cases that we've conflicted out of going into APD. And I know that that's been reported at the board level as well. So you see a reduction in of our conflicts without the civil matters and without the wall. So I could just see, as Edie Hattori had just mentioned, you'll see less conflict. Next slide. This is just a bar chart.
Can we go back to the conflicts, Kathy?
Sure.
Can we go back to the conflicts? So how does it reduce a conflict? So if you, because right now, if you represent somebody in a protective order, you can't represent the perpetrator in the criminal case because you have a conflict there.
Your
So
Honor,
how would that reduce conflicts?
So
Your
just like in APD, right? If there's a criminal case with a co-defendant, APD, because of the conflict wall, can handle that. Similarly, if we have a civil division with a conflict wall, they'll be able to handle protective orders, and there won't be a conflict with the criminal one because of the conflict wall that we're gonna create. And so that addresses the concern for conflicts.
and may I also
But
add?
the conflict wall only is good as, because, if the director of the public defender still can hire and fire people, civil attorneys in the civil division, there is a conflict there, because if you feel that the person is not performing, but the person you feel is not performing feels that you're firing him or disciplining him because of something he did, you still have some control over that individual, don't you?
Well, similarly, like with APD, right? I have cases personally that APD handles, but
yeah,
I don't
but Annie Gale controls the APD. You have no say so on how attorneys are being hired, etc.
Well,
it's Annie Gale that decides who gets hired, not you.
That's correct. So we've done some research on it, and so there is some case law that says as long as the director doesn't manage the actual files, there's less of a conflict. And it's similar to what's going on at the AG's office, where there's a Chinese wall or conflict wall between the family division and prosecution. And as long as the AG doesn't read their files, that conflict wall is sufficient. And so that's, I don't really, if we want to set them up just the way like APD set up, I'm perfectly fine with that. I mean, I don't really need to have day-to-day management control over that office, and I definitely wouldn't ever need to see any files or get involved in the handling of the cases. And so that's something that we could create with what we've done with APD. It's proven effective. So that would be, and the other way would reduce conflicts is, so like some protective order cases, clients we have to turn away because we represent them in a criminal case. If we have a civil division, that's not going to happen. We'll be able to help more protective order victims get protective orders. And so that's another way that it will reduce conflicts.
So let's go an example. Elderly abuse, okay? You write a power of attorney for a person, the public defender drafts a power of attorney for Madame Ko, okay? It's later found out that the person she gave the power of attorney to absconded with the money in her bank account. Now, if the person, has no money and can we still appoint the public defender to represent the person who absconded with the money?
The criminal side could be appointed to represent the defendant accused of embezzling the money, even though the civil side is the one that prepared the power of attorney. Just like APD currently represents a co-defendant, like in a drug case, we can allege that it wasn't our client, it was APD's client, even though we're all under the umbrella of the PDSC family. Because of that conflict wall, it's permitted. Because otherwise, it really calls into question whether APD can, the conflict wall for APD is sufficient. I mean, we're going to build it up as high as the one APD currently has, and APD has for actual conflicts. And so the Justice Elder Center isn't really dealing with, there are no determined actual conflicts. They're all theoretical or potential conflicts. But
you can't, to me, I see APD and this one as apples and oranges, personally. Huh?
Well,
APD accepts conflicts because public defender cannot represent them because of a conflict of interest, or there's multiple defendants in a criminal case.
I understand. It's just that the theory of a conflict wall is the same between those type of cases.
Okay.
So.
Okay.
I know. I'm just still kind of disturbed about that.
Yeah, and I'm sorry. It's patterned after, like, New York City. They have a legal aid office that handles criminal cases and civil cases, but they have a conflict wall so that there's no conflict between the offices. So the Elder Center will have a managing attorney that is not necessarily answerable to me. They'll be answerable to the board.
So who will be the managing attorney for this program?
Well, I guess
We haven't identified anybody yet. We haven't identified anybody. We've talked to several folks about who would manage the program. Until we get the program, there's nothing. I mean, like I had mentioned, we have somebody we've identified. There's no commitment as a possible individual who can run the program. But what we want to do is just get past the board's approval of allowing this to happen.
Yeah, but Kathy,
I'm concerned.
Let me just ask, who have you identified?
We were looking at Pablo Aglaba. We've actually talked to him. He wants to come back and work with us. And we've also talked to a Cat Focus, right? She's another person that we've looked at. So those are two individuals that we've talked to. We're hoping Richard Dirks could probably even work with us again.
Okay.
The chairman, Chief Justice, this is Attorney Mahi. I would ask that we have an opportunity to review some of this information. We've been talking about potential conflicts. We're being told that there is a memorandum of some sort between legal services and PD, and that there may be some legal research and an opinion that was reached regarding this conflicts matter. I think the relationship between Guam Legal, the hiring of employees under the PD, these are all very particular circumstances that will aid our determination of whether or not the setup of this type of process will result in a conflict or not. So for example, Steve, you had just indicated that if we hire a managing attorney to run the civil side, that you will have no authority over them. Well, the way that we got your organization set up now is you're the executive director. You are the one who manages the day-to-day operations and not the board. The board oversees the operations, yes, but this is why we have an executive director to manage the day-to-day. Now, if we are hiring attorneys for this purpose, then why are we entering into a partnership agreement with Guam Legal Services as well? These are a lot of questions. And what's the scope of the services that legal is going to be providing? Under what circumstances can they say they are no longer fulfilling a portion of a scope of service for the PD, especially when it comes to potential conflicts? So as you see, we have a lot of questions, and I think there are more questions the more we spend time on this. Unfortunately, Chief Justice, I have another meeting starting in a few moments.
All right.
And I would ask if it was possible. If
Donna, Jackie, all right, I recognize you. We have a few more minutes to go, and then I'll let you know how we're going to proceed. Donna, we're gonna end this discussion at 2 p.m. But I'm gonna give Donna, who requested to speak, and then we'll decide how we're gonna proceed.
Thank you, Your Honor, to the PJ and to Attorney Jackie. I hear what you're saying, but in life, there are more no's than you can get yes. And if we don't start somewhere, we're never going to start. We've done it before. We've proven we can do it. They've proven their caseloads can handle it. So we need to start somewhere. And I think starting now would be a good time. And I understand what you're saying about COVID. The governor's supposed to be lifting a lot of more of the restrictions before the end of the month, from what I understand. So that shouldn't even be an excuse, because each and every one of us are going through great lengths to protect our employees, to protect our families, to protect and us to protect our clients and our employees as well. So I don't think that would be a reason, and nothing against the statement you said, but we need to start now. We need to get back to the normal way of doing life. And if we don't start now, I'm sure the public is looking at us wondering, when are we going to do this? And there's so many times that I hear that. I mean, you can talk about abuse to the manumku. They don't got nowhere to go. So I'm asking, the sooner that we can start this, I think it'd be better for all of us concerned, especially to our manumkos. That so far what I have to say, Your Honor. But if you want to put the policies and the procedures, or how we're going to handle it, or how the conflict wall is going to work, or all that, we've been able to get through that when we set up the APD. So I am sure that we will go through great lengths to make sure that we will not put ourselves in a position that we don't want to be in. But we need to start taking care of our manuncles now, not tomorrow, not 10 years from now. We need to do it now. Thank you, sir.
All right. So we have, it's now 1:54. We said we're going to end this at 2. The president has to leave for a meeting. So do I, and the presiding judge. So my thinking on this is that this matter will be voted on at the next meeting, and we're going to need 2 resolutions to address the issue and make a decision. One resolution, and Steve and staff, John Morrison, you're going to prepare this resolution in draft form for the consideration and deliberation of the trustees. One is to modify the moratorium to allow this legal assistance services program with the Department of Public Health and Social Services. And so that we are very specific that any exception to the moratorium is only for this specific program at this point in time. And the second resolution is to approve this legal assistance program on a pilot trial period for a period of 6 months, and with conditions. And the conditions are all as set out and I can work with the in reference to drafting the resolution, what those conditions are, which are pretty much outlined by the concerns expressed by the board members. Number one, it's a pilot program. Number two, it has a conflicts process mechanism in place. And number two, it doesn't tap into the resources of the Public Defender Service Corporation General Fund, and the other conditions that concerns that have been addressed and have been shared and are in a large part in this slides. And then if this could be circulated to the board members 5 days before the next meeting, so that if they have any amendments they wish to make, they can do so. at the next board meeting, and we either vote it up or vote it down. And I think we just need to dispose of this so we can move on if it's such that it does not receive the support of the trustees because of the concerns regarding some of the compromises that it's going to be making to the primary objective. So I will recognize you, Jackie. Do you want to? I have you. You have your hand up. Go ahead. You have to.
Yes, Chief Justice, so I would make a motion to table it per the information you have provided, inclusive of the preparation of the resolution, and that this matter should be tabled until the next regular meeting.
All right. Is there a second?
Chief Justice, can I just make an amendment to that? Because,
Yes.
I'm just concerned about the conflict. So if Steve can prepare a memo so that it can alleviate some of our concerns on the conflict issue, I would appreciate it so that we can study it.
All right.
Is that okay to add to Jackie's, Mr. Lahi's motion?
Yes, and that is a separate document, Steve, and in reference to addressing the conflicts wall that is going to be set up and how it addresses the concerns regarding any ethical issues that the PJ and Jackie has raised, and so if you can also do further research and provide any authorities and maybe a sample in reference to whether this has been tried in other areas.
Your Honor, may I add something, please?
Yes, Donna.
Based on the pilot program on the timeline, if the budget's is the budget only for 6 months or is it
Well, I mean, Mr.
2 years?
Sanagostine, Art, if I understand.
Normally the first couple of months.
Well, we can revisit that, Art, if I mean, right now we're coming up to the end of the fiscal year. And my understanding is that this allows for a rollover use of the funds. And so at the end of the fiscal year, if those funds are not drawn down, that it can be rolled over into the next fiscal year. And I'm thinking, nothing is set in stone. We all have one vote, and we'll all have the opportunity to weigh in. I'm thinking that at the end of a 6-month period, we go back and reevaluate. Are the concerns of the PJ realized that it creates more conflicts, and therefore our primary focus in criminal indigent defense is compromised? Then we need to revisit and see if this is something that the Board of Trustees should continue to support. But if it turns out that the conflicts have not materialized, and if what Mr. Hattori is saying is that it in fact will reduce any potential conflict, then I think we're servicing the segment of our community that everyone agrees. The bottom line is that there is a need and there is a sincere effort in terms of trying to provide the legal representation to this segment of our community. And so it'll just give us an opportunity to reevaluate after 6 months. And if it turns out that we get 3 votes next week, that it'd be for 1 year, then we'll revisit that. I want us to have a starting point so that we can end this discussion at the next board meeting.
Okay, Your Honor, thank you.
Do you need a second? I'll second the motion as amended.
All right,
Chairman.
thank you, PJ. All right, all those in favor, please say aye.
Aye.
Aye. Okay, it's been unanimously adopted. And so is there any item under new business? Executive session, we don't need to go into executive session. We've already addressed Mr. Morrison's memorandum and the effect of it. And so anything on public discussion? All right, so we will adjourn, and our next meeting will be on Tuesday, July 28th at 12:30 p.m. And so at this time, I would entertain a motion to adjourn.
Move to adjourn,
Motion.
move to adjourn to July 28th, 12:30.
All right, and it's been seconded by
Second.
Ms. Munya Kanata. All right, there being no objection, this meeting is duly adjourned, and I really appreciate all the sincere comments and in reference to the topic. I know it's a very sensitive matter, and it's just a matter of our priorities and resources, but no one questions motives and the desire to help our elderly. Thank you all, and we'll
you.
see you all next month.
Thank you, Your Honor.
All right.
Thank you, everyone.
Okay, have a good day, everybody.
Thank you so
Thank
much.
You too. You too. Thank you. Thank you, PJ.
Okay, take care, Cynthia.
We're out. Yeah. And